Welcome back to further explorations of the UCC Section 2708. Section 2708, subparagraph 2, doesn't only cover lost volume sellers. There are other circumstances in which the damages calculated according to 2708, subparagraph 1, might be inadequate. Let's consider a hypothetical. Imagine a seller, Smergo, entered into a contract with a buyer, Bisco, whereby Smergo would manufacture and sell 200 toaster ovens to Bisco for $60 per oven, for a total of $12,000. Bisco repudiates the agreement while Smergo is manufacturing the ovens. Because the market for toaster ovens is dismal, Smergo stops manufacturing them. Smergo sues and proves the following facts. The market price for ovens, if completed at the time and place of tender, was $7,000. Smergo can sell the material he's amassed for manufacturing the ovens for $3,500. Smergo will have $800 in cost of shipping the ovens to the buyer if the ovens were completed and sold. Smergo has incurred $6,000 in expenses at the time of the breach. Smergo would have to spend $600 more to perform the contract, and Smergo has allocated overhead at $10 per oven for a total of $2,000. What would damages look like under 27081, and what would they look like under subparagraph 27082? Plugging in the data we have to the formula provided in those provisions would get the following. That for 27081, we'd have the $12,000 contract price minus the $7,000 market price plus $0 for incidental damages minus $800 as the expenses saved for shipping, which equals $4,200. Note that this amount does not take into account the amount Smergo has incurred in expenses, his overhead, or the value of manufacturing materials. Well, what would damages be under 2708, subparagraph 2? One formula offered by Professor John Siebert for calculating damages under that provision in cases that don't involve lost volume is as follows. You take the unpaid contract price minus total variable costs, plus incidental damages, plus reliance damages, minus the proceeds of resale, minus expenses saved. And here's how subparagraph 2 damages would look like. They would be equal to $12,000 minus $6,600, plus 0, plus $2,500, minus 0, minus $800, which all adds up to $7,100. The first formula does not capture Smergo's expected profits, including fixed cost, nor his reliance damages. The second formula does and would produce a greater damage. So in this case, Smergo would want to argue that subparagraph 2 damages were appropriate because subparagraph 1 would be insufficient to put him in as good a position as if the buyer had performed. Catch your breath, and now let's consider another mathematical hypothetical. Suppose a middleman agrees to supply 9,000 units of goods to a buyer in 6 regular installments on July 1st and on January 2nd of every year for 3 years at $100 per unit. At the time of the first scheduled delivery, which is July 1st, the market price for the goods was $95 per unit. At that time, the seller delivered 1,500 units. But by December 1st, the price plummeted to $45 per unit. The buyer repudiated on that date. At this point, the seller had a forward contract with an option to purchase 1,500 units for the next installment at $75 per unit and had no other goods or forward contracts. On the date for the next delivery, which is January 2nd, by which time the market price had now dropped to $40 per unit, The buyer rejected the second installment and said he would take no more deliveries. The seller sued. On July 1st, the intended date of the third delivery, the market price was now at $50, but was expected to gradually recover. The seller wanted to use 27081 as the basis of recovery. The buyer believes this will overcompensate the seller. Can you see why? Well, consider the goods at the second delivery date. The contract price minus the market price, that is the measure of damages under subparagraph 1, would be $60 per unit. But because of the buyer's option contract at $75 per unit, the profit would have been only $25 per unit. Some courts would limit seller's recovery here because with his option contract, he had hedged the risk of a declining market price. But in the third delivery, where there was no forward contract under 27081, the seller would be able to recover $50 per unit, the $100 contract price minus the $50 market price. The remaining intended deliveries initially appear more complex because we do not know what the market price at the time and place of tender would be for these future deliveries. But a different UCC provision, Section 2.723.1, provides that in such situations where the time for performance has not yet occurred, the market price at the time the seller learned of the repudiation, which here is $45, will be used to calculate damages for all these remaining delivery times. So the seller would get $55 per unit for all these final delivery times. As these examples suggest, the damage calculation rules can lead to very different and somewhat perverse results for different installments. We've packed a whole lot into this two-part video. So let's summarize what we've learned. First, we used Locke v. Wade to discuss lost volume sellers. Then we introduced and discussed UCC provision 2708 and the differences between subsection 1 and subsection 2. Finally, we applied these subsections to two different mathematical hypotheticals, and together we calculated damages under each.